Welcome, everyone. We're delighted to welcome you all to the first of our lunchtime speakers for the International Law Summer Institute. My name is Sarah Sack. I'm being co-directing with Neil Kreck, our International Summer Law Institute, ILSI. ILSI? No, did I get that wrong? I'm very pleased to welcome our first speaker, who is Professor Valerie Oosterveld from Western University, a colleague of mine. Professor Oosterveld is the Associate Dean, Research and Administration at Western Law, and she teaches public international law, international criminal law, and international organizations. Her research and writing focus on gender issues within the international criminal justice system, and she's also Associate Director of Western University's Center for Transitional Justice and Post-Conflict Reconstruction. She's also affiliated with the Department of Women's Studies and Feminist Research. Prior to joining Western, Oosterveld served in the Legal Affairs Bureau of Canada's Department of Foreign Affairs and International Trade, where she provided legal advice on international criminal accountability, especially with respect to the International Criminal Court. She's also served on the Canadian delegation to the 2010 review conference of the Rome Statute of the International Criminal Court. Most recently, Valerie was inducted into the Royal Society of Canada's College of New Scholars, Artists, and Scientists in the fall of 2014. So I welcome Valerie very much. Thank you for agreeing to contribute your extensive expertise to our conversations today.
Well, thank you, Sarah and Neil, for inviting me here today. It's a real honor to be with you and to come and talk to you about something that I'm very passionate about, which is the International Criminal Court and international criminal law. And within that, I'm going to give examples stemming from my experience dealing with sexual and gender-based violence. So I thought I would divide my talk into 3 parts today. The first part is to give you a sense of the role that states and non-governmental organizations played in the creation of the International Criminal Court, or ICC. Secondly, I thought I would explain a bit about the International Criminal Court's jurisdiction, what it can do and what it cannot do. For some of you, this may be old hat if you've studied the ICC before, but for some of you who have not been exposed to the ICC, it will give you a sense of what it can do, what it can't do, and what its limits are. And lastly, I thought I would mention the court's track record to date in dealing with the prosecution of sexual and gender-based crimes. So to start, I'm going to go back in history a little bit. The idea for an international criminal court has been around for a very long time, but it became serious in 1872, when Gustav Meunier, one of the founders of the International Committee of the Red Cross, proposed a court in response to the crimes of the Franco-Prussian War. So that idea came up, it was discussed, but then it was set aside, and it was set aside until the next serious call for the creation of a permanent international criminal court, and that was from the drafters of the 1919 Treaty of Versailles. And at that time, they were envisaging a court to try the Kaiser and German war criminals from World War I. Following World War I, of course, we know that there are temporary international criminal tribunals set up in Tokyo and in Nuremberg to try individuals for war crimes, crimes against humanity, and crimes against peace. And then in 1948, those who were drafting the Genocide Convention decided to include a clause in the convention that says that criminals who have committed genocide should be tried by such international penal tribunals as may have jurisdiction, and then invited the International Law Commission, which is a group of independent experts who help to progress international law. And they were invited to study the desirability and possibility of establishing an international judicial organ for the trial of people charged with genocide. And in fact, the International Law Commission did create such a draft statute in the early 1950s, but then the Cold War intervened and the whole idea was shelved for quite some time. Let's fast forward to 1989. In 1989, Trinidad and Tobago, so a tiny Caribbean country, raised the issue within the United Nations of creating a permanent international criminal court. And the idea caught on. And it's quite fascinating because Trinidad and Tobago raised this idea because they wanted a court to try drug traffickers, whereas everyone else wanted a court to try genocide, war crimes, crimes against humanity, etc. In the end, Trinidad and Tobago did not get what it wanted, but it prompted this whole movement to create the International Criminal Court that we have today. So, as a result of Trinidad and Tobago's request, the International Law Commission resumed its work and created a draft statute for an international criminal court. That draft statute had not one aspect of gender sensitivity to it. The word gender is not in it, sexual violence is not represented in it, and there is nothing about treatment, gender-sensitive treatment of victims and witnesses. This draft statute was given then to the UN General Assembly. And the UN General Assembly created something called the Ad Hoc Committee on the Establishment of an ICC. So it looked at the draft statute, and then in bureaucratic fashion, it then put it to another group. So it created something called the Preparatory Committee on the Establishment of the ICC. And the goal of the Preparatory Committee was to create a consolidated text. So a text taking the original draft statute done by the International Law Commission, but then taking all of the states' points of view and putting them in, or at least those that were agreed, into the draft statute. So that Preparatory Committee was drafting the statute or negotiating the statute between 1996 and 1998. From the very beginning, non-governmental organizations were involved. They were monitoring the progress of what was being discussed, and they were influencing the discussion as well. There were two ways in which it did this, the non-governmental organizations. First of all, many of the states that were involved in the discussions did not have very much knowledge or expertise in international criminal law. So in fact, it was the non-governmental organizations that were educating the states on international criminal law. And recall that at the time, there were two operating international criminal tribunals, one for the former Yugoslavia and one for Rwanda. And then, of course, there were the Nuremberg and Tokyo tribunals, so there wasn't a whole lot of international criminal law out there in terms of of development in that area of the law. So it was the non-governmental organizations that taught, in essence, many of the states about the content of what happened in Nuremberg, Tokyo, the Yugoslav and Rwanda war crimes tribunals. And the other thing that they did, of course, is many of these organizations are human rights organizations. So they brought to the table human rights requirements for fair trials and due process, how to treat victims and witnesses, and what kinds of things should be considered crimes. So they were lobbying as well as educating. The NGOs came together and created the NGO Coalition for an International Criminal Court. This coalition became very large and relatively powerful in terms of non-governmental organizations within that time period of 1996 to 1998. It grew to include 2,500 civil society organizations, today in 150 different countries. So these negotiations were going on, and the non-governmental organizations were tracking them. And feminist lawyers within the non-governmental organizations started to notice that there was not very much of a focus on the lessons learned from the Yugoslav and Rwanda war crimes tribunals on how to deal with sexual and gender-based crimes and how to deal sensitively with victims of these crimes. And as they were noticing the negotiations going on, they decided to do something about it. So in February of 1997, they began to come together, And by the next set of negotiations in August of 1997, they had created something called the Women's Caucus for Gender Justice in the ICC. And the Women's Caucus grew rapidly, and grew rapidly not only in numbers, but also in influence. So the Women's Caucus began officially lobbying states as a group in and of itself in August 1997, and quickly found that they had allies on the floor of the negotiating room. If you've ever been in the United Nations or in an international negotiation, you'll know that on the floor of the room are the states, because states negotiate treaties. And then further up or on the outside, if they're permitted in, are the non-governmental organizations, as well as international organizations. So on the floor of the room, there turned out to be quite a few allies for the Women's Caucus. And the Women's Caucus would lobby these allies, and the allies would take, in essence, the requests of the Women's Caucus and put them on the floor to be discussed by states. Sometimes they would alter them if they didn't feel that, diplomatically speaking, it was going to be a successful, the way the Women's Caucus proposed it would be successful. But at any rate, there was this movement from the NGOs, from the Women's Caucus, out onto the floor in terms of states putting forward ideas for inclusion in the statute. And very quickly, the Women's Caucus started to chalk up some major successes in new language being added into the draft statute. I came into this picture in December of 1997. I was a graduate student at the time at Columbia Law School in New York City, and I had been asked by a Canadian NGO for whom I'd worked before to, would you please go to the International Criminal Court negotiations and represent us within the Women's Caucus? And it was, of course, an unbelievably wonderful thing to be asked to do as a graduate student, because I was writing my thesis on sexual and gender-based violence issues in international criminal justice. And here I was right in the middle of the creation of a brand new international criminal justice organization. As an aside, one of my supervisors at Columbia said, you know, you really shouldn't do this because it will take you away from the writing of your thesis. And I'm very glad that I ignored that advice. So I came in through the non-governmental route, and I was lobbying on behalf of the Women's Caucus. I was assigned to lobby Canada because I'm Canadian, and worked with another Canadian on doing this. Canada was one of those states that was very open to receiving thoughts of the Women's Caucus at the time. And in fact, I would call it a partnership of sorts, whereby we would meet on a regular basis with the Canadian delegation almost daily to put forward views on how the negotiations were unfolding, the avenues we thought were open to make the statute more gender sensitive, and inevitably Canada would propose these things on the floor. So it's, again, as a graduate student, it's quite something to give words to a state delegation, and then they put those words on the floor, and then they get accepted by the states. So that was fantastic. So it's all good news stories so far in terms of making the statute gender sensitive. However, this success led to a backlash. At first, the backlash was very quiet amongst states, conservative states, specifically the Holy See, and conservative Arab states. At first, they were very quiet, and they would raise issues in the corridor discussions, not on the floor, not in public, and say things like, well, we're not sure about using the term gender in the statute, or we're not sure that there needs to be special expertise in sexual and gender-based violence within the Office of the Prosecutor. But as the successes mounted of the Women's Caucus and the states that were supporting the Women's Caucus ideas, the backlash grew stronger as well. And as a result, by the time we got to just prior to the final conference, which was called the Rome Conference in 1998, the number of Christian far-right religious organizations from the United States and Canada that were participating as non-governmental organizations, not in the Women's Caucus, as you might imagine, and not in the Coalition for an ICC, but separate from them, was growing. And they were becoming more organized. So let's set that aside for a moment. I'll come back to the negotiations of the final diplomatic conference in a moment, but I wanted to mention something that was also very important on the political landscape at the time. Canada's Minister of Foreign Affairs at the time was Lloyd Axworthy. He had a vision for Canada's role in the world that was based around human security. Part of the human security agenda was gender sensitivity. So he told the Canadian delegation that he wanted to see a gender-sensitive statute emerge from the final set of negotiations coming from Rome. He wanted the International Criminal Court to be gender-sensitive. And as a result, he appointed an expert, which turned out to be me, and it was totally amazing again, as a graduate student, to be asked to be on the Canadian delegation as a gender expert. He wanted that so that there would be a point person on the delegation that could focus and make sure, as best as possible, that the statute was gender sensitive. The diplomatic conference took place over 5 very intense weeks in Rome, Italy, in June and July 1998. As someone brand new to the delegation, I had to learn the ropes very, very quickly. And sometimes I learned through making mistakes. So for example, one of my first really intense negotiations where we were clashing, Canada, Australia, New Zealand, and others were clashing with Syria and Qatar on gender issues. I made a mistake, which I now see as a classic diplomatic mistake, where I was asked the question by the chair as to how it was all going in terms of figuring out how to deal with a particular provision. And I opened with a critique of one of the states that was in the room. It was Syria at the time. Syria is refusing to negotiate on how to solve this problem. And everyone in the room just went, "You never, in the world of diplomacy, directly criticize another state in the room." So I learned the hard way. But I did learn the ropes, and I learned them very quickly. At the Rome conference, NGOs were heavily represented. There were hundreds of non-governmental organizations working with the Coalition for an International Criminal Court, and also large numbers working with the Women's Caucus from all over the world. The stakes were high. The diplomatic conference, either we would have a statute at the end, or it would fail. And we wanted, those of us who were in support of an ICC wanted it to succeed. Therefore, everyone was very vocal because the stakes were so high. So whereas states had remained relatively quiet before on particular things, especially those who were against the sexual and gender-based provisions that were proposed in the ICC, they became very vocal. There was a lot of pushback, in other words, in the negotiations. Now, for those of you who read my paper on the negotiations, you'll know that one of the most contested issues was the definition of the term gender in the ICC statute. The negotiations on the term gender were very difficult. In fact, they turned out to be one of the most difficult issues, alongside what other people called heavyweight issues, assuming that the gender issues were not heavyweight, like whether the UN Security Council would control the caseload of the International Criminal Court. I would argue that the gender issues were just as heavyweight as that sort of issue. Non-governmental organizations like the Women's Caucus were pressing for the inclusion of the term gender on the basis that the word in and of itself, from a legal perspective, from a social perspective, from a political perspective, was important. In armed conflict and in mass atrocity, people are targeted for violations such as sexual violence based on gender, socially constructed norms of maleness and femaleness. The new ICC needed to be able to prosecute persecution on the basis of gender. It happened in World War II on the basis of sexual orientation, and we should not foreclose the possibility of trying crimes on the basis of gender, persecution on the basis of gender in the ICC. However, I've told you before that there was a group of non-governmental organizations and states that allied together to lobby against this, to press against this, and they were lobbying to exclude the term gender, claiming that inclusion of the word would create human rights that might protect homosexuals and transgender people and might increase women's reproductive rights, and they were against this. However, although there was a very strong presence of amongst this group, when the final negotiations came, in the end, it really turned into a state-to-state issue. So while there were very strongly held views amongst non-governmental organizations on whether or not the term gender should be included, in the end, as we got very close to the end of the diplomatic conference and this issue was not resolved, the issue went into the back rooms, which excluded the non-governmental organizations. It was only states were in those back rooms. And then, in fact, the way international negotiations work on really difficult issues is there are back rooms to the back rooms. And these are called informal informals. So Canada, Chile, Qatar, and Saudi Arabia were tasked with, in an informal, resolving the issue of the inclusion of the term gender in the Rome Statute. So on the yes side, so I'll call us the yes side, Canada and Chile met with a group of states, one-on-one and also in large groups, to find out their views, their thoughts, any solutions they had in mind, and that was also done on the other side, on the no side, so to speak. They discussed with the Holy See, with Syria, and other opposing states. So in the end, we adopted a definition, and it was very challenging to negotiate it, but it was a definition that was accepted by all of the people in the room. It was not necessarily the ideal definition, and I certainly would never say that it's an ideal definition. It was a definition that intentionally contained ambiguous language. In the diplomatic world, this is called constructive ambiguity. And the reason why it's called constructive ambiguity is because it allows the treaty to be finalized at that time. However, it can also be considered destructive ambiguity because over time, the ambiguity in and of itself means that no one really knows exactly what it means. It can mean one thing to one person, another thing to another person. But that's how it was resolved. So at the end of the diplomatic conference, 120 nations voted in favor of the adoption of the Rome Statute, 7 nations voted against, and 21 states abstained. So success. There was, in fact, the Rome Statute of the International Criminal Court. And in the end, that was a very gender-sensitive Rome Statute. In fact, it's the most gender-sensitive international criminal law document ever. It has a relatively long list of gender-related crimes, as crimes against humanity, and set out as crimes against humanity and as war crimes. These are rape, sexual slavery, forced prostitution, forced pregnancy, forced sterilization, other forms of sexual violence, and, as I mentioned before, persecution on the basis of gender. We also succeeded in getting articles included on the need for expertise on gender issues among the judges, within the office of the prosecutor, and in the registry. And the registry is the organ of the International Criminal Court that deals with victims and witnesses issues. So it's very important in this often overlooked part of the International Court. There were also articles on the need for the judges and the prosecutor to take into account the type of crime that the victims have suffered in determining things like victim and witness protection and how they will be treated in the courtroom. We also ensured that the procedures of the court, again, another part that's often overlooked because it's so technical in nature, were as gender sensitive as possible, learning from the mistakes of the Yugoslav and Rwanda War Crimes Tribunal, which had some pretty serious episodes of non-gender sensitive procedural activity in those courts. We also had a revolutionary victim participation scheme, which allows victims to have their own lawyers in the courtroom as parties. And for those who know civil law systems, this won't be so revolutionary because this happens in civil law systems. But for those of us who are trained in the common law system, it is revolutionary because normally at the domestic level in a courtroom in a criminal case, you've got the Crown and you've got the defense. But the victim's voice, where is it? Maybe in a victim impact statement, maybe in testimony, but maybe not. In the International Criminal Court, they have their own voice through their own counsel, and they can raise their own concerns. There's also a scheme for victim reparations and for the creation of a new body called the Trust Fund for Victims. So in all, Canada and a number of other countries, not just Canada, as well as the non-governmental organizations, including the Women's Caucus, partnered together to ensure that the ICC statute is gender sensitive. In April of 2002, the 60th ratification was filed, and that meant that the ICC could be created, and it was on July 1st, 2002, and it became operational not that long afterwards. In fact, it was something that I had worked on at the Department of Foreign Affairs, how to create a court from scratch. As an aside, it's quite something when someone says, oh, okay, we're going to have this court. It's not just on paper, it's going to be in reality. Where are we going to get the photocopiers from? And the staplers, and the people, and the chairs, and the desks, and the building? Those sorts of things. As a lawyer, you don't normally sit around thinking about them, but when I was at Department of Foreign Affairs, we started to work on these issues. So that's the story of the negotiation of the Rome Statute and the involvement of non-governmental organizations with states. So I'm going to talk a little bit about the ICC. The ICC, as I mentioned, became a reality in 2002. The ICC has boundaries on what it can and cannot do, and if you read the press, it's not always clear what those boundaries are. So I'm going to mention them here. First of all, the ICC has jurisdiction at the moment over 3 crimes: genocide, war crimes, and crimes against humanity. That leaves a lot of things off the list, many different human rights violations, for example, that do not qualify as crimes within the ICC. The International Criminal Court also has a specific kind of jurisdiction. It's called complementary jurisdiction, which means the ICC cannot act if there are genuine proceedings going on at the domestic level. So it's a court, it's meant to be a court of last resort. We can talk about this in Q&A. It doesn't always actually turn out that way, but generally speaking, that's the goal, is to make it complementary. Proceedings can come to the ICC in 3 different ways: by a state party referring a situation, by the prosecutor acting on his or her own motion, and lastly, through the UN Security Council. The UN Security Council, by virtue of the UN Charter, can refer any situation in the world that is on its agenda to the International Criminal Court. And in fact, it's done so in Libya and in Darfur, Sudan. Before the ICC can exercise criminal jurisdiction, though, there has to be some form of state acceptance. In the case of a Security Council referral, it's inherent in the fact that the Security Council is acting under the UN Charter. So it doesn't matter if the state they're referring has accepted the ICC or not. And in fact, Libya and Sudan have not. However, in the absence of a Security Council referral, the state of nationality of the accused or the state in which territory the crime was committed has to accept the jurisdiction of the court. So that also excludes certain cases from coming before the court, because if it's not a Security Council referral, then if the state of nationality has not ratified the International Criminal Court statute, or the state in the territory of which crimes occurred has not ratified, then the ICC cannot take jurisdiction. The ICC is also not retroactive. So when a state joins, then, well, first of all, it doesn't go beyond 2002 because the court didn't exist before 2002. But the jurisdiction is also limited by when the state concerned, or the territory of the state concerned, depends on when that state ratified as well. The ICC can only deal with adults. So the ICC will only prosecute those who are 18 years of age and older at the time of the commission of the crime. But the ICC does have very broad jurisdiction in terms of the types of people it can indict. It can indict anybody if it fits within those other jurisdictional parameters. A person's capacity is irrelevant. They could be the head of state, they could be a foot soldier, they could be a civilian, they could be a guard in a camp. All of these people are fair game, so to speak, for the ICC, although the prosecutor has made a policy decision to focus on as high in the chain of command as possible. Right now, there are 123 states parties, so 123 states have ratified. That's good. That's more than half of the states in the world, but it's not all of the states in the world. There are 22 cases in 9 situations before the International Criminal Court. There are 4 states parties that have referred cases to the court: Uganda, the Democratic Republic of Congo, and the Central African Republic, as well as Mali. The Security Council I mentioned has referred 2 situations to the court, and then the prosecutor has, on his or her own motion, brought cases before the court in Kenya and with respect to Côte d'Ivoire. And the Office of the Prosecutor currently has preliminary investigations in a number of places: Afghanistan, Georgia, Guinea, Colombia, Honduras, Korea, and Nigeria. So let me go back to my example of the gender-based provisions in the ICC statute. The story of gender sensitivity does not stop with the adoption of the Rome Statute. In fact, it starts with the creation of the International Criminal Court, because what we've often seen in international law, especially with respect to gender-based discrimination, is that there might be good words in a treaty, but they don't always get translated into practice. And in fact, the International Criminal Court has had quite a mixed beginning with respect to gender and sexual-based crimes. So I mentioned a number of provisions that were adopted into the Rome Statute of the ICC, and in fact, for the most part, these have been implemented by the International Criminal Court. There have been good intentions, but they haven't translated always into reality. For example, the prosecutor of the International Criminal Court has been very good in terms of recognizing that sexual violence and gender-based violence is widespread in conflicts around the world. And if you look closely enough, you'll find that it is in most, if not all, of the conflicts and situations of mass atrocity around the world. So the prosecutor has brought charges of sexual and gender-based violence in the majority of cases before the ICC. So that's good. It means the prosecutor is aware, is looking closely, is investigating. On the other hand, 40% of the charges of sexual and gender-based crimes have failed at different stages of the ICC. The ICC has a couple of stages, more than a couple of stages, but the 2 most important for our purposes are the confirmation of charges stage and then the trial stage. And at both of those stages, the ICC has a relatively poor record of being able to prove to the required standard. The prosecutor has failed to prove to the required standard these charges. Why? First of all, there has been a record of investigations not gathering strong enough evidence. Poor investigation practices have meant that in some cases, there's been an over-reliance by the prosecution team on published documents by Human Rights Watch and others. Those documents are helpful, but they are not proof beyond a reasonable doubt. Proof beyond a reasonable doubt comes from experts, direct witnesses, and victims. And the ICC prosecutor has not always brought those individuals into the courtroom to support the charges to the crime, so they've failed. The other aspect, or another aspect, is that the prosecutor has not always explained why something is sexual or gender-based and what that means in the context of the attack that's being looked at. And because of that, the judges have sometimes recharacterized the evidence as not sexual or gender-based at all. Certain of the judges have taken regressive approaches, deeming rape and sexual slavery as unforeseeable consequences of a malicious attack against civilians in a village. In other words, pillaging and murder are deemed as foreseeable consequences of a militia attack on a village, but rape and sexual slavery are viewed as unforeseeable, and therefore an individual cannot be held liable if he's part of the overall plan to carry out that attack. Another way the judges have been regressive is determining that rape or sexual slavery are already covered by other crimes. Oh, you know, they fall under other crimes, so we don't really have to focus on those. We can get rid of those. And lastly, amongst the victims who are registered with the court, so those who are represented by the special legal counsel, victims, the majority of registrants have for quite some time been male. And what that means is that the voices of female victims are not always represented through the voice of the victims' counsel. It's gotten better over time, but the ICC really is struggling with how to access the voices of women through that special procedure. And this has happened because the court has done outreach in many of its situation states, but hasn't figured out the best ways to access women. So for example, if they go into a village and they announce, we're going to hold a meeting, we're going to talk about the ICC, those who will come to the meeting are often male. Why? Because the women are often in the field farming, or they're cooking, or they're looking after the kids. So the ICC has, over time, figured out some ways to go through women's organizations, to have meetings at times of the day that are most conducive to them. They tried something really interesting and innovative, which was to have outreach via radio in the Democratic Republic of the Congo. But what they hadn't realized is that in the one particular area where they were doing this, the radios were generally viewed as being owned by men. So the men would take the radio during the day to wherever they were going, whatever work they were doing, and the broadcasts that were meant to be listened to by the women as they were doing their work were actually being listened to by the men. So that didn't succeed very well. But as I said, over time they've learned some lessons. It is getting better. But what these examples show you is that the quest to ensure gender sensitivity in the International Criminal Court is never ending. It's not something that just happens because the statute itself is gender sensitive. It happens because of consistent efforts both within the ICC and monitoring from outside of the ICC. I could never say, hey, we're done. I could switch to a new area of international law because I'm done on the gender stuff in the international criminal law. Not in my lifetime, I don't think. But there is some good news I wanted to end with, and that is that in June of 2014, the prosecutor of the International Criminal Court issued a groundbreaking policy paper on sexual and gender-based crimes. It's comprehensive, it's gender sensitive, as you might expect. The prosecutor has then taken strong efforts to enforce this policy paper in every way, shape, and form. And it seems to be working. And her oversight seems to be very strong on this. 2014 was the very first year in which all of the gender-based charges were confirmed within the International Criminal Court. And they didn't fail. So that's positive. This brings me to my final comments. In my work at Foreign Affairs and in my academic life, I've seen the need for a great deal more research, exploration, an explication of gender issues in international criminal law. I've been working on this for 20 years, but I feel like we're only at the very beginning of understanding the role of gender in atrocities, in genocide, in war crimes, in crimes against humanity. We can't stop at the beginning. We can't say, okay, we've got rape and sexual slavery and forced sterilization and forced pregnancy in the statute, we're good. We have to think deeper. We have to think about things like, why did that occur? Why did the rape occur? Why were only men targeted or only boys targeted for this? And why were only girls targeted for that? There's usually a gender explanation that underlies this. It may also be political, cultural, religious, etc. But there's often a gender explanation in there. And if we can understand the gender explanation, we can understand how to explain it within the court, we can understand better the harms that were done more deeply, the harms that were done to the victims of sexual and gender-based crimes. We can understand better how to sentence those crimes. There's a great deal more work to do. Thank you. So I'm open to questions of any sort. They can be about gender issues in the ICC, they can be about the ICC, they can be about international criminal justice. Go ahead.
Hello, thank you so much for that wonderful talk and for all your hard work in the field. I was wondering that recently there's a development in international law where rights groups have been able to use human rights law to bring tort cases in the United States against Shell, and also stitching mothers in Srebrenica in The Hague. And I was wondering that a lot of these gender-based crimes are, to target an individual is always kind of overlooking how gender can be institutional, systemic. So a whole military, a boys' club understanding. So I was wondering that what if any of these developments could empower any groups to bring a tort case not against a commander or soldiers, but against a whole military or any type of agreements surrounding gendered crimes for states.
Possibly is the answer. I think that domestic tort law, at least in Canada and the United States and in some other places, would need to be developed quite a bit more before this could happen. And we've already seen in Canada the Hud Bay case, in which rape was one of the violations, human rights violations that was alleged, and they had success at the preliminary level to allow the case to go forward. But that only came after years and decades of these sorts of claims being denied. So we see an opening in Canadian law for these sorts of things. But we also see how strong, and we'll talk about this afternoon, how strong the law of immunities is. Now, the law of immunities doesn't necessarily apply in the context in which you're talking about, but the law of immunities does apply in situations involving peacekeepers or international organizations, and that therefore excludes the possibility of a large number of cases involving people who rush in when disaster is happening. So the door is open a tiny bit. What you're thinking of is much more revolutionary than even what's going on right now. And in order for that, I think the door would have to open more.
Thank you. How will you react to the allegation that the International Court is targeted at African countries and countries in the developing world? Then secondly, do you have an update on the case on the Kenya's president? Yeah, thank you.
So what you're referring to is the fact that all of the situations under the court's jurisdiction at the moment, officially under the court's jurisdiction at the moment, are based in Africa. And I have two conflicting thoughts on that. One is the thought, which I agree with, by the prosecutor, who's from Gambia. The prosecutor addresses this by saying, that's true, but the ICC is looking at, in a preliminary way, conflicts from all over the world. So I read you the list in Afghanistan, in Colombia, etc. And she says, in the situations in Africa in which she is investigating and bringing cases, she points out that she's been invited in, for the most part. Not in Darfur, not in Libya, but in the other places she's been invited in. And not in Kenya either. But in the other cases, she's been invited in. So she says, look, I've been invited in, and also one of the largest groupings of states that are party to the Rome Statute is the Africa group. It is, if I'm not mistaken, it would be either the largest or the second largest group. So this is what the prosecutor sets out when she's asked this question, and I agree that these are all valid points. On the other hand, there's the issue of perception as well, and I think she knows that. She doesn't speak to it directly, but there's this perception that the conflicts in Africa are easier for her to go after than in other places. And that raises some very interrelated issues that we have to be cognizant of. So I think there's some validity to that it is easier to go into the Democratic Republic of the Congo than it is to go into Afghanistan, for example. And in terms of investigations. But it also raises the issue of the prosecutor's budget. The prosecutor has a very limited budget. And in here, I told you all the positive story about Canada, et cetera. Canada has also been a very hard-line force on the budget issue at the ICC, requesting every year that there be a zero increase to the budget. And because of that, the prosecutor has not been able to expand the investigations to more places and more areas because she doesn't have any more money from one year to the next. In fact, she has less because of inflation. So if we take that into account, then there should be some blame placed on states as well, not only the prosecutor and her choices or the choices of her predecessor, but also on states. So I think it's a complex and nuanced issue, more complex and more nuanced than has been discussed so far, at least in the media. And on the Kenya president, I don't have any updates at all because of where the case was set aside. The prosecutor claims because of interference by Kenya in the evidence, and therefore she didn't have enough evidence to prove the case beyond a reasonable doubt. And it's going to just sit like that. And what that shows is, apart from what the law says in the Rome Statute, there are very, very strong issues related to politics and state cooperation that influence what the prosecutor can and cannot do. It really can restrict her ability to prove a case. Yeah.
Could you give us an indication of the kinds of arguments that the Holy See and the Arab countries were using in those early stages, and whether there were any that, from a legal perspective, you found the most difficult to overcome?
All right. There's one argument that, to go straight to your last bit of your question, was there a legal issue that was difficult to overcome when defining the term gender? And the legal issue was this. It is called nullum crimen sine lege, no crime without a law, and it's part of something called the principle of legality. The principle of legality says that you cannot prosecute someone for a crime that did not exist at the time the crime was committed. Because the term gender had never been defined in international criminal law before, and in fact had never been included in an international criminal law statute before. We faced the argument from the Holy See and from the conservative Arab states that this did not meet the principle of legality. And I think that that certainly gave us pause. However, having examined the law on it, we felt satisfied that it did not violate the principle of legality to include gender, for example, under one of the grounds of persecution as a crime against humanity, because gender had been referred to so many times in the last decade prior to the Rome Statute being adopted in state-negotiated UN documents. So there had been, in legal parlance, some opinio juris, or views, binding views, that certain violations, including gender-based violations, were just simply unacceptable. And the term gender had been used many times, for example, in the outcome document of the World Conference on Human Rights in 1993, in the Cairo document of the UN World Conference on Population and Development in 1994, etc. So while that gave us pause, there was, I think, a fair legal argument that could be made. There were then social arguments that I think did not give us pause because we just didn't agree with them. The social arguments were twofold. One is that the term gender, this is according to the Holy See and the conservative Arab states, that the term gender contains within many hidden meanings. And the hidden meanings include, according to them, homosexuality, transsexuality, pedophilia, bestiality. And they argue that's what gender means, that if you use the term gender, it allows all of these things. It somehow gives an imprimatur to all of these things. Now, from our point of view, of course, homosexuality, sexual orientation, transgenderism, we should be protecting those people, right? We should be protecting them. This is the Canadian point of view at the time. They should be protected from persecution. We want them to be protected from persecution. So if the term gender includes that, that's good. The other social argument was related to this because it's a fear of granting rights on the basis of sexual orientation. And it really came out in comments by Azerbaijan in one of the public forums. Many of these were said in private forums, but in public forums, Azerbaijan said, won't this give rights on the basis of sexual orientation? Won't the use of the term do so? And that really encapsulated the fears of the Holy See and the conservative Arab states. But these are social, not legal, and it didn't, because we didn't agree with the fear, it didn't worry us from a legal perspective. In fact, we felt that it was important due to, from a domestic perspective, to ensure that the rights that are protected under the Canadian Charter were also those that were protected in different ways throughout the Rome Statute.
Yes. When the court was being negotiated, When the court was being negotiated, one of the arguments in favor of it was that its mere presence would serve as a deterrent, that leaders would think twice about engaging in committing mass atrocities because they could one day be prosecuted. Is there any evidence that that has held up?
That's an excellent question. You're correct that as the court was being negotiated and as the Rome Statute was being adopted, one of the arguments that was put forward for having this court was this deterrent effect that it would presumably have. The problem, of course, has been to prove a negative. So to prove that someone did not act to carry out genocide, war crimes, or crimes against humanity as a result of the presence of the court. I think we can fairly say that the ICC in most situations does not have a deterrent effect, in part because of lack of knowledge. So there are many places in the world where no one even knows what the ICC is or that their country may have ratified this statute. And then there are other places where they don't care because the ICC hasn't shown up on their doorstep. They haven't shown that the ICC hasn't shown that it has this robust presence everywhere at every time in a conflict. So if they're not present, then who's watching? On the other hand, we have anecdotal evidence, if you want to call it that, or anecdotes at least, from various conflicts around the world, where individuals will say, for example, to trainers from the International Committee of the Red Cross or Geneva Call, an NGO based in Geneva, they'll say, we're worried about this International Criminal Court. Can you help us understand what the laws are so that we can figure out what we can and cannot do? So this sort of anecdotal information being passed on shows that there's somehow, somewhere, sometimes, deterrence perhaps, or at least shaping of actions because of the presence of the ICC. There are some, I understand, some studies going on at the moment to try and measure in a more provable manner, if I can put it that way, that there is some kind of deterrent effect. But they are not, I understand they're not finished, those studies yet. So I think the question is still out. But what you will have noticed is since 1998, when the Rome Statute was adopted, and then since 2002, when the ICC has been created, those who work in international criminal justice have tended to turn away from using the deterrent argument because, for these exact reasons, they can't prove it. Yeah. Here.
Thank you for that presentation. And I have a question that's not so much on the law, but on the really interesting dimension of negotiations. And I wondered how much the experience of the Cairo Convention informed how one approached the criminal court, because it sounds quite similar in terms of who was involved in resisting that language.
Yes. So what's very interesting, and I appreciate your question because I believe strongly that international relations and law intersected very strongly on this particular issue in terms of the outcome in the Rome Statute. So in Cairo, for those of you who don't know, in 1994, there was a UN World Conference on Population and Development. And in that conference, there was a very contested discussion around sexual and reproductive rights of women and girls, and also of the use of the term gender, which had stemmed, in fact, from 1993, the UN World Conference on Human Rights. So what you should note, though, is that happened in the human rights community. So in the human rights community, there was contestation, there was a real butting up of points of view between human rights organizations and especially the Christian far right, the Christian right-wing US and Canadian NGOs and the states that ally with them. Okay, International Criminal Court negotiations. For the longest time, states sent their military representatives to the negotiations. Military representatives had no idea what went on in Cairo or whatnot, so their minds were fully on international humanitarian law and the technicalities of it. And then states also sent the delegates who are based in New York, at the missions in New York, who may or may not have human rights exposure. And they also sent Department of Justice representatives who have experience in domestic criminal law. So you have in the negotiation rooms, for the most part, throughout 1995 to early 1998, these sorts of people. And it was the gender aspect that then brought this whole human rights scenario into the room. And the states and the NGOs went, oh, we better get the human rights people talking to us. We better find out what happened in Cairo, in Beijing in 1993, or sorry, in Vienna in 1993, in Beijing later on. We should try and connect these two. But because the NGOs who had been butting up against each other in those fora became aware, they were much more quickly mobilized than the states were to respond to this. And this is in part why Lloyd Axworthy thought we better have a gender expert on our own delegation, because of the people on the delegation, none of them have that particular expertise. And I was in 1993 in Vienna. I wasn't in Cairo, but I was in Beijing, so I'd seen that. It was a reaction, in essence, to that. But states move much more slowly than NGOs, so this was part of the problem, that by the time we got to Rome in 1998, in June and July 1998, that debate had moved squarely within the room with the states, but not all the states were ready for it. That's why the negotiations went so late. That's why, that's why it took so long to resolve, is states were trying to get their head around, what did we do before? What was the history of this? What are human rights doing in this room? We should be focusing on military stuff, shouldn't we? Or at least war-related stuff. So that had a very big influence.
Thanks very much for your comments and very interesting insights on the ICC's gender sensitivity. I'm wondering what your sense is of the ICC's sensitivity to cultural diversity. And I'm thinking less about issues that cross-cut gender and more about procedural issues, for example, or cultural differences around what counts as a just outcome. Is that a conversation that is going on at the ICC in your observation?
That's a really good question. And if you don't mind, I'll step aside for a moment and mention something, then I'll come back to that. I was also involved in setting up the Special Court for Sierra Leone. So that's a time-limited court actually based in the conflict country, and it was unlike the Yugoslavia and Rwanda war crimes tribunals for that reason. There were many discussions on culture and justice in Sierra Leone because of the presence of the court. There's still criticism, of course, that it was based on the other tribunals and not reflective enough, but much more focus on what does this mean for Sierra Leonean culture in that special court. I'm not sure that all the lessons learned in Sierra Leone, and there are many positive lessons, have come over to the International Criminal Court for a couple of reasons. One is the ICC is much more bound in terms of the number of rules and regulations that it must follow, and there's a very specific procedure that doesn't allow for more input. For example, the discussion of, well, maybe should we wait? If there's a Truth and Reconciliation Commission, should we operate after that commission, or should we operate before or in conjunction? Because of the strictures of the rules, once things are in the system, they just keep moving up and up and up and up. So that's one aspect to it. The second aspect is that there's not enough staff in the court. So the Special Court for Sierra Leone was small, but when you look at the number of people on the investigation staff assigned to assist the prosecutor there, it was much more intensive than it is in the International Criminal Court, where they can have a 6, 7, or 8-person team for an entire area the size of France and the Democratic Republic of the Congo, for example. So more people who are immersed in the culture in the area where the conflict occurred means naturally more exposure to the cultural issues in Sierra Leone as opposed to the ICC. And last but not least, the cultural issues are, so there have been some glimmers of hope in this respect, where the court has shown a potential willingness to hold parts of the trial in situ. In the Democratic Republic of the Congo, for example, they've been mooting this for other situations as well. Now, it hasn't actually happened, but it's being discussed and considered and decided upon. And I think if the court can get from The Hague into the country, that's going to change the situation somewhat. Maybe not enough to be as culturally sensitive as even the Special Court for Sierra Leone was, and even there were criticisms, but it will go farther than the ICC has come so far. There is another part of the ICC that we haven't talked about. I mentioned it earlier, the Trust Fund for Victims. The Trust Fund for Victims is the success story in this regard. So while the ICC proper has not, the Trust Fund for Victims is operating at the community level in a very culturally specific way in various parts of the Democratic Republic of Congo and Uganda. And I think we shouldn't lose sight of the fact that the trust fund is part of the court, even though most people overlook it, and that it is quite successful in this regard. No? No more questions? All right. Should we wrap up? Great. Thank you very much.
I just want to thank Professor Oosterveld very, very much for that fantastic talk. For everybody in the International Law Summer Institute, I think we have a half-hour break or so, and we'll start back at 2 o'clock in the other room. Thank you all very much. Western, Oosterveld served in the Legal Affairs Bureau of Canada's Department of Foreign Affairs and International Trade, where she provided legal advice on international criminal accountability, especially with respect to the International Criminal Court. She's also served on the Canadian delegation to the 2010 review conference of the Rome Statute of the International Criminal Court. Most recently, Valerie was inducted into the Royal Society of Canada's College of New Scholars, Artists, and Scientists in the fall of 2014. So I welcome Valerie very much. Thank you for agreeing to contribute your extensive expertise to our conversations today.
Well, thank you, Sarah and Neil, for inviting me here today. It's a real honor to be with you and to come and talk to you about something that I'm very passionate about, which is the International Criminal Court and international criminal law. And within that, I'm going to give examples stemming from my experience dealing with sexual and gender-based violence. So I thought I would divide my talk into 3 parts today. The first part is to give you a sense of the role that states and non-governmental organizations played in the creation of the International Criminal Court, or ICC. Secondly, I thought I would explain a bit about the International Criminal Court's jurisdiction, what it can do and what it cannot do. For some of you, this may be a Genocide Convention, decided to include a clause in the convention that says that criminals who have committed genocide should be tried by such international penal tribunals as may have jurisdiction, and then invited the International Law Commission, which is a group of independent experts who help to progress international law. And they were invited to study the desirability and possibility of establishing an international judicial organ for the trial of people charged with genocide. And in fact, the International Law Commission did create such a draft statute in the early 1950s, but then the Cold War intervened and the whole idea was shelved for quite some time. Let's fast forward to 1989. In 1989, Trinidad and Tobago, so a tiny Caribbean country, raised the issue within the United Nations of creating a permanent international criminal court. And the idea caught on. And it's quite fascinating because Trinidad and Tobago raised this idea because they wanted a court to try drug traffickers, whereas everyone else wanted a court to try genocide, war crimes, crimes against humanity, etc. In the end, Trinidad and Tobago did not get what it wanted, but it prompted this whole movement to create the International Criminal Court that we have today. So, as a result of Trinidad and Tobago, old hat, if you've studied the ICC before, but for some of you who have not been exposed to the ICC, it will give you a sense of what it can do, what it can't do, and what its limits are. And lastly, I thought I would mention the court's track record to date in dealing with the prosecution of sexual and gender-based crimes. So, to start, I'm going to go back in history a little bit The idea for an international criminal court has been around for a very long time, but it became serious in 1872 when Gustav Meunier, one of the founders of the International Committee of the Red Cross, proposed a court in response to the crimes of the Franco-Prussian War. So that idea came up, it was discussed, but then it was set aside, and it was set aside until the next serious call for the creation of a permanent international criminal court, and that was from the drafters of the 1919 Treaty of Versailles. And at that time, they were envisaging a court to try the Kaiser and German war criminals from World War I. Following World War I, of course, we know that there are temporary international criminal tribunals set up in Tokyo and in Nuremberg to try individuals for war crimes, crimes against humanity, and crimes against peace. And then in 1948, those who were drafting the
Welcome, everyone. We're delighted to welcome you all to the first of our lunchtime speakers for the International Law Summer Institute. My name is Sarah Sack. I'm being co-directing with Neil Kreck, our International Summer Law Institute, ILSI. ILSI? No, did I get that wrong? I'm very pleased to welcome our first speaker, who is Professor Valerie Oosterveld from Western University, a colleague of mine. Professor Oosterveld is the Associate Dean, Research and Administration at Western Law, and she teaches public international law, international criminal law, and international organizations. Her research and writing focus on gender issues within the international criminal justice system. And she's also Associate Director of Western University's Center for Transitional Justice and Post-Conflict Reconstruction. She's also affiliated with the Department of Women's Studies and Feminist Research. Prior to joining
those requests, the International Law Commission resumed its work and created a draft statute for an international criminal court. That draft statute had not one aspect of gender sensitivity to it. The word gender is not in it, sexual violence is not represented in it, and there is nothing about treatment, gender-sensitive treatment of victims and witnesses. This draft statute was given then to the UN General Assembly. And the UN General Assembly created something called the Ad Hoc Committee on the Establishment of an ICC. So it looked at the draft statute, and then in bureaucratic fashion, it then put it to another group. So it created something called the Preparatory Committee on the Establishment of the ICC. And the goal of the Preparatory Committee was to create a consolidated text. So a text taking the original draft statute done by the International Law Commission, but then taking all of the states' points of view and putting them in, or at least those that were agreed, into the draft statute. So that preparatory committee was drafting the statute or negotiating the statute between 1996 and 1998. From the very beginning, non-governmental organizations were involved. They were monitoring the progress of what was being discussed, and they were influencing the discussion as well.